tātou. He hono rei ki te, he koroare ki te atua, maungarongo ki te whenua, whakaro pai ki ngā tangata katoa. Ko tēnei mihi tuatahi ki te atua, nana nei te timata me ngā mutongo ngā me katoa. Nō reira, ka nui te kōtaku nākau, e tū ana ki a mihi atu ki a koutou katoa. Ngā ka nohi ora, ngā karangatanga, no tēnā, koutou, o ngā whare mahi, o tēnā roia, o ngā kaunihera, huri noa te motu. Koutou ngā karangatanga maha, nau mai, haere mai ki o te poti, ki te taha o te tai o tākau e reri ana kei waho rā, i te maru o ngā maunga whakahi o tēnei taone, ko tēnei mihi atu ki a koutou. Koutou, ko tae mai nei, e hāpai ana te kaupapa o tēnei hui nui. So many blessings to your conference. Welcome to Otepoti. I'm standing here and welcoming you on behalf of the local hapu, Kei te Ruahekeheke. It's great to see you here in Dunedin City. We trust that your conference will be productive. You'll expand your knowledge and understanding and go forth and apply out there amongst the resources that are important to us all and certainly to us. Ko tēnei te mea nui mō tātou ngai iwi Māori, ngā taonga e tuku ana ki a tātou mai o tātou nei tūpuna, e wāwata hea, e whakauru tanga tātou e roto ngā mahi whakahaere, e pāna ko tātou nei rawe, o te ao tūro, ko tēnei he kaupapa nui mō tātou. So like you, it's a very important kaupapa for iwi hapu, to be close to their taonga, to participate, be involved, and to be influential in the way that those special resources are managed. So we ask you to take that on board as you think about your work and apply it out there amongst your regions, your places that you come from. Ko tēnei te wā tō tātou nei whakaro ki a rātou ngā mate kei ronga koutou mō tātou i tēnei taha, ngā mate o te wiki me te tau, ngā mate mai te rerenga wairua tai atu ki Rakiura, whiti atu ki rea kohu ngā mate haere moe mai, oki mai. So we take this moment also to think of those who have passed and bid them on their way. Haere moe mai, oki mai. Koutou, ngā waka, ngā reo, ngā mana, ngā hau e whā, ko tēnei he kaupapa tika o tēnei hui nui o koutou, he kaupapa nui mō tātou e te kaupapa te kāwana hau, ki whakatika te ture RMA Act, ko tātou nei wāwata hea, ki kaha tēnā wāhanga i whakahaere o tātou nei iwi hapu i roto tēnā kaupapa mahi i whakahaere o tātou nei taonga, ngā kaupapa e pāna o koutou nei mahi e pāna o tātou nei taonga huri noa te motu, e te tūranga mō tātou. Pokahiwi ki te pokahiwi o ngā kaunihera, me ngā roia koutou, ngā tare, ngā whare mahi o rātou, ngā kai mahere tanga o te Aotearoa. So one of the important things for us that's currently happening is the reforms proposed by this new government, and for us, iwi hapu, it could be a mixed bag, and we're hoping that we see strengthened involvement and participation, better pathways for tangata whenua to be involved in the planning processes and governance control of ngā taonga tuku iho. Nō reira, koutou katoa, tēnā rā koutou, ko tēnei mihi tautoko koutou nei kaupapa me o koutou nei huinga, o te RMLA, tēnā rā koutou, tēnā koutou, kia ora tātou katoa.
Kia ora tātou. Welcome to Dunedin. Haere mai, no mai, whakatau mai. I'm Dave Cull, I'm the Mayor of Dunedin, and it's a great pleasure for me to welcome you to our city. I understand it's 6 years since this conference was here, so welcome back. Your conference is occurring at probably one of the most critical times in the 23 years that the RMA has been with us. As Edward alluded, and as we all know, currently there is intense pressure to overhaul the RMA with the ostensible objective of greater speed and efficiency of process for RMA applicants and their developments. It's difficult to argue against the demand for economy, efficiency and effectiveness. The objective is worthy, at least on the face of things, but what might be the collateral damage? How greater efficiency might be achieved and at what cost to the aims, objectives, purposes and even integrity of the RMA is a far more vexed question. The original aim of the RMA was to promote the sustainable management of natural and physical resources. So I guess it's pertinent to ask, are the proponents of change arguing that these aims can be achieved while development and the processes that facilitate it are sped up? Or are they saying that environmental values have been given too much weight and that the purpose should change? That's a rhetorical question, since no one will say the latter out loud, even if that's what they mean. So we come back to the how question. Simplistically, there are two ways to achieve greater development efficiency, obviously two among many others. The first is to change the RMA to favour development over the environment, and that would be legislative change at central government level. The second way is to at least partially achieve the effect, is to change the rules within district plans to give greater certainty of process and outcomes prior to or as a substitute for hearings. And that's obviously a local government function. Additionally, as was noted in the invitation that you received to this conference and the introduction at the beginning, it was noted that there's a current discernible trend towards centralised control and decision-making at central government level in New Zealand at the moment. The dangers of that, among other risks, are one-size-fits-all approaches that do not take into account local nuances. If we believe that decisions that affect local economies should be made as much as possible at local level and with local support, then in the face of government stated intentions, the onus is on local councils to make their district plans and processes as clear and certain as possible. Otherwise, centrally ordained regulations and law changes could be brought to bear that could override the perhaps in some cases not too clearly stated intent of our district plans. They may be anyway, but there would be less justification and they might not have the same sweeping effects. So that, for what it's worth, is my take on one significant aspect of the broader debate around RMA reform. There are many other complex issues to be grappled with, and I'm sure you will be doing that in the next day or so. So I wish you well in your discussions, and I trust that some significant and instructive learnings and suggestions will come out of this conference. These are incredibly important issues for our communities, and I know that the whole local government sector and all the individual councils within it are deeply concerned about the ramifications of any proposed changes. Can I also take the opportunity to invite you to experience as much of our city and its environs as you can with the time that you have here in our city. I don't believe there's a more varied cityscape with such high quality environments, be they heritage architecture, coastal or hinterland, in any city in New Zealand. So enjoy your city, our city, enjoy your conference, and I sincerely look forward to hearing the learnings from it. Kia ora.
Thank you, Mayor Cole, and thank you, Edward. And good morning. For those of you who I didn't meet last night, my name is Jeremy. I'm your MC for today. For those of you who, like me, had difficulty getting to Dunedin, it wasn't Dunedin's fault this time. It was Christchurch's. I mentioned that last night, but we're going to stick with that. A little bit of housekeeping before we kick things off. Firstly, as the Mayor said, please get around and see some of the wonderful sites in Dunedin. You're very close to some of the iconic sites, the Robbie Burns statue. We are, of course, in the Town Hall, beautifully refurbished. Across the road is the Cathedral. And for those of you staying at the Scenic Hotel, across the road from that is the Disc Den, the CD shop, which has been here as long as anyone can remember, and no one remembers ever buying anything there. So please pop in. It's amazing that they're in business. It is a very small town. It's very easy to get around, so enjoy that. Just to give you an indication of how small, Mayor Cole, I'm not sure if you remember, you were my landlord in my last couple of years here, so I apologise for that. We have a little bit of housekeeping just to get underway. For those of you who haven't been in here before, the toilets are just outside where you came in. If you leave here on the right, down one little set of stairs. There is Wi-Fi in the building. The code is on screens outside. I'll give you the access code. This is the code to get in. Just to point something out, that is a lowercase l. So for those of you like me who have tried a 1 and an I and couldn't get on, that's why. So it is case sensitive. Use the Wi-Fi code, because with the Wi-Fi code you will be able to access the app for this conference. Now the instructions to get hold of the app are on page 16 of your handbook. It is the Show Gizmo app, and that will access speaker bios, more information about the conference. It will send you notifications. It'll tell you more about the workshops over the next couple of days. It should be very self-explanatory. If there's any issues, if it asks you for an access code, which I realise will apply to some of you depending on which email is registered with it, the access code is lowercase RMLA numbers 14. So that's RMLA 14. Any issues with any of that, please see the helpful staff at the registration desk. And again, if you haven't found that, it's outside and down to the left. Right. We have a great day ahead of you. We have keynote speakers, we have workshops, and then this evening you've got a culinary delight, which I'll explain a little bit more later on. Any questions throughout the day, feel free to approach me and I'll help where I can. I understand about as much of the RMA as... no, I don't understand anything about the RMA, so I'm looking forward to today as much as anyone. So we're going to kick things off with your first keynote session. And I'd like to introduce the chair to kick things off today, Dr. Royden Somerville, QC.
Kia ora tātou. Good morning, ladies and gentlemen. It gives me great pleasure to welcome and introduce to you Professor Liz Fisher. Some years ago, I developed an interest in how the language of risk could be applied when considering reasoning methodologies for addressing the development of policy and planning instruments. In 2001, I came across the work of Liz Fisher when she authored a chapter in the textbook Reinterpreting the Precautionary Principle. I continue to follow the development of her thoughts in respect of the precautionary principle in her subsequent writing, For example, with Ronnie Harding, she wrote in The Precautionary Principle and Administrative Constitutionalism, developing frameworks and implementing the precautionary principle. I consider that Professor Fisher moved to the forefront of scholarship in the area of environmental law and risk in 2007 with the publication of her book, Risk Regulation and Administrative Constitutionalism, which won the S. Alias Peter Burke's Prize for Outstanding Legal Scholarship. Professor Fisher now focuses her research in the areas of environmental risk, environmental law, risk regulation, and administrative law. She has described environmental law as hot law, and today we are going to hear why that description is relevant to New Zealand environmental law. Professor Fisher's academic work has been heavily influenced by her in-depth understanding of administrative law and what she calls administrative constitutionalism. Professor Fisher is Professor of Environmental Law at Corpus Christi College and lectures in the Faculty of Law at Oxford University. She convenes the environmental law courses in the faculty and from October 2013 is the Vice Chair of the Law Board of the faculty. She is the General Editor of the Journal of Environmental Law and has served as the Editor of Legislation of the Legislation Reports section of the prestigious Modern Law Review. Professor Fisher, we look forward to your paper Towards Environmental Constitutionalism, Environmental Law and the Reframing of Decision-Making Structures. Ladies and gentlemen, please welcome our first keynote speaker, Professor Liz Fisher.
Thank you very much. It is both an honour and a pleasure to be here. My paper is about hope and imagination. If we go back 23 years to the passing of the RMA, it was a time of great hope, not just in New Zealand, but across the world. It was a time in which there was a belief that if we put in place new legal frameworks for environmental protection, those frameworks would deliver. If we think about international law, the Rio Declaration, if we think about the process in Australia about ecologically sustainable development, amendments to the Treaty of the European Union, they're all about the idea that legal instruments would deliver environmental protection. And the RMA was in many ways the most ambitious and exciting of those legal reforms. 23 years on, and we've seen it in the discussions yesterday and the discussions already this morning, that hope looks dashed. What we're seeing across the world is a disillusionment in those frameworks, a belief that they didn't work and that they should now be overhauled, repealed, rolled back. Our hope seems to be misplaced. But in this paper, I want to imagine environmental law in a different way. I want to suggest that these frameworks were never instruments, they were never tools to deliver environmental protection. I want to suggest that we should, rather than thinking of them as just sort of machines, we want to think of them as constitutions. And if we think of them as that way, what we begin to see is that the RMA and environmental legislation in other jurisdictions was about starting legal conversations. And if we see it that way, we begin to see a more constructive vision for the future. So what I want to do this morning is three things. First of all, I want to talk a little bit about the nature of environmental problems and environmental law. Secondly, I want to explore this idea of the RMA as a constitution and this rather jargonistic-y term of constitutionalism. And finally, I want to consider the implications of that. Now, in doing all of this, I have a caveat. I'm a legal scholar. I always have caveats. And that is, I do not pretend to be an insider to New Zealand legal culture. Royden talked yesterday about, at this conference, needing to take a step back. I feel I'm taking a step forward, closer to the RMA, but even in doing that, I do not have the expertise that you have, and I look forward to the conversation after my paper. Okay, so to begin with, if we think about this image from the early 1990s about the idea of the RMA delivering sustainable management or sustainable environmental protection, I think there are two interesting things about that image. The first is that it rests on a notion that environmental protection is a sort of one-trick policy agenda, and that if it didn't deliver, then we kind of get rid of it. But environmentalism was never that way. Environmentalism is a complex body of social and political thought. And its starting point is the point that within societies and industrialised societies, we cannot act as if we're independent spheres occasionally knocking into each other. We must develop legal frameworks which figure out how do we manage those interactions between each other and between the natural environment. Secondly, and I think this relates to points that the Mayor just made, while there is a great discussion about the need to reform environmental legislation, there is generally a commitment to the environmental protection levels that we already have. No one is saying that we want to live in a garbage dump. There is simply the belief that we don't need the environmental laws to make sure that we don't do that. But the history of law shows us why we need environmental law. And in particular, a paper recently by Lord Carnwath of the UK Supreme Court. Sorry, I'm just aware that there's people coming in, so I will I will let them. Great, thank you very much. Lord Carnwath pointing out that in the history of law, what we see are disputes coming to court because of the environmental impact of industrialisation. Victorian Britain is a perfect example of this. Some of you, this is a slight joyful aside, some of you may be noticing my shoes. My children call my shoes my cholera shoes. And the reason they call them cholera shoes is we went to an exhibition about Victorian Britain, and these were the type of shoes that you wore in the first half of the 19th century because the sewage and dirt and pollution on the streets of London. Law, even if we do not have environmental laws, and this was the point of Lord Carnwath's paper, cases will come to court because of the disputes that arise from the environmental impacts of different activities. We cannot escape that. And as Lord Carnwath said in his paper, he said in these cases, pragmatism and principle were uneasy bedfellows. Now, for me, and I'm afraid this point is where we get into economic sociology, so bear with me, this uneasiness is caused by the fact that environmental problems are what we call hot situations. Now, I take the term hot situations from the work of Michel Calon, who is a French economic sociologist, and he distinguishes between cold situations and hot situations. And he describes a cold situation as a situation where actors are identified, interests are stabilised, preferences can be expressed, responsibilities are acknowledged and expressed. And what this means is in a cold situation, actors can figure out what they want to do, they can assess the costs and benefits, and they can get on with their lives. Contract law is a perfect example of a cold situation. A contract, we know that the parties are the parties to the contract. We know the contract is regulating that relationship. We know the contract doesn't manage everything, but there's a kind of assumption that the things it can't manage can be identified and managed in other ways. We can also think of criminal law as setting the boundaries for acceptable behaviour and making them cold situations. But Callan points to the fact that environmental problems are hot, and he says, in hot situations, everything becomes controversial. The identification of intermediaries and overflows, the distribution of source and target agents, the way effects are measured. These controversies, which indicate the absence of a stabilised knowledge base, usually involve a wide variety of actors. The actual list of actors, as well as their identities, will fluctuate in the course of a controversy itself, and they put forward mutually incompatible descriptions of future world states. So what Callan is pointing to is in environmental problems we have polycentricity. We have many actors which exist in complex relationships with each other. We have scientific uncertainty. We have socio-political conflict. And most importantly, we don't have frames for managing that conflict. And this has two important implications. It's common to throw around risk and scientific uncertainty in environmental law. But the point is, these aren't just trendy words. These are operational aspects of the subject, as all of you as practitioners and scholars know. The second thing, and again, particularly if practitioners know this, unlike contract lawyers, we don't, as environmental lawyers, have the luxury of working in well-honed legal grooves, hollowed out by centuries of case law. We are often operating in context where there aren't agreed legal frames. Now, of course, environmental legislation is a response to this. It is creating frames to address, although not eradicate, the polycentricity, the scientific uncertainty, the socio-political conflict. But those frames we have hot situations, and then we have hot law. And the reason is those frameworks themselves are not fixed. They are frames that often cut across pre-existing legal structures, ideas of property ownership, ideas of central local relations, ideas of separation of powers. Likewise, the frames of environmental law that we create are nearly always administrative in nature. And I think this is an important point. When I talk about constitutionalism, people often think I'm talking about high-level government issues. But actually, I am talking about public administration. And the reason is to deal with hot situations, we need to create new institutions and new frameworks that deal with the collection and assessment of information, which empower and enable different forms of expertise and consultation, and which allows for the consideration of specific cases. Now, these frames are addressing these hot situations. They are cutting across pre-existing legal frameworks. And in doing so, they require legal expertise. Just to give a feeling for this in relation to the RMA, I would suggest that there are three features of the RMA which are three features which we see in similar legislation in other jurisdictions. Now, that's not to say that the RMA is exactly the same as those pieces of legislation in other jurisdictions, but I think it's important to note. The first is that the RMA is managing local central relationships. Because in thinking about hot situations and thinking about polycentricity, we need to think both at the local level and also at the regional and the central government level and sometimes the international level. The second feature of the RMA is that it deals with both decision-making and dispute resolution. It is in many ways creating a new separation of powers in environmental issues. And I think that's interesting to note. It's recognising the fact that in hot situations, it's not just the decision-making, it's how we resolve the inevitable disputes that arise. And third, the third feature is the reliance on what scholars call soft law. That we're not just relying on traditional legal ordering, legislation, common law precedent. We're creating policies of many different sorts because we recognise that in framing decision-making, there are many different sorts of legal authority that we might want to empower. So my argument so far has been to suggest that the hot nature of environmental problems leads to hot law. Now, you may be thinking, this is really negative, and it's not very kind of positive. You're pointing to the fact that environmental law is difficult. But I think if we do not recognise that fact, we fall into this idea of thinking that environmental law is just a tool. We also, in a sense, fail to recognise the expertise that we need. Okay, so moving on from this, and this idea that environmental legislation is not just dealing with hot situations and therefore is hot law, but also we should think about it in constitutional terms. Constitutions, and as soon as I say the word constitution, there's a temptation to think that I'm talking about rights, entrenchment. That's not what I mean. What I mean is that if we look at the RMA and other pieces of legislation in other places, it has a foundational quality. It is acting as a power map, to use the language of the constitutional theorist Vernon Bogdanor. What it is doing, it is in many ways a structural endeavour. It is a device of recognition. And we can see this, and this is not my point to go through the RMA section by section, that would be cruel and unusual punishment. But if we look at it, what it's doing is it's setting out the principles, the overarching principles that govern in Part 2. It is setting out in Part 3 the foundational ground rules for development. It is allocating powers. It is a meta-law that creates an overarching structure. As I've said, it creates its own form of the separation of powers and its own form of hierarchy. And in this sense, we can think of it as what Joseph Raz has described the thin sense of constitution. And by a thin sense, what he meant is that it is constitutive of the legal and political structure. And there is therefore an expectation that it is, to use his language, stable, written, superior, justiciable, entrenched, and that it reflects the common ideology of the culture. Now, constitutional lawyers know that these things can mean different things. Entrenched does not mean an American-style constitution. Things can be entrenched in other ways. Likewise, and this is the most important point, I think, is that a common ideology does not mean that everybody agrees. As Cass Sunstein, the US public lawyer, notes, a central role of constitutional arrangements and constitutional law is to handle widespread and even enduring disagreement, partly by turning disagreement into a creative force, partly by making it unnecessary for people to agree when agreement is not possible. And in regard to this final point, Sunstein points to the importance in constitutional law of incompletely theorised agreements, that is, practices and outcomes in situations where people do not agree. And his point is legal reasoning plays a fundamental role in those situations. Now, what all this reflects is that in thinking about environmental legislation in this thin sense of constitution, we are immediately recognising that round it is a discourse about what it means, a discourse about what it should mean, a discourse that reflects disagreement in society. And that's why I use the language of constitutionalism. My mother, the book that Royden mentioned, my mother, when it won its prize, she said to me, "That's very surprising, dear, because the title was so boring. I fell asleep by the end of it." And I think it was that word constitutionalism that was doing it. But in a sense, constitutionalism is a word that is recognising that we have debate about what is a constitution. It is not just simply a tool. And I'm not using it in the sense to talk about rights or any kind of entrenched sense. I'm using it in its more ancient form to talk about a debate about how do we constitute and limit decision making. So what, you may say? This might make us feel warm and fuzzy in an academic way. It might be kind of introducing new kind of words. But how does it help us in thinking about the debate over the RMA? Well, what I want to suggest is it helps us in three important ways. And these may seem obvious, but it also seems to me these can get lost in the debate. The first is that it makes clear there are no simple and self-executing solutions to environmental problems. Now, you all may be sitting there and saying, yeah, well, that's obvious. But if we go back to the 1990s, what seems striking to me is that, particularly because environmental legislation at that time had bipartisan support, the RMA was no exception to that, was that there was a belief that actually they were solutions in themselves. That was the era where we talked about win-win regulatory strategies. We now talk about market solutions. But the reality is, if we recognise, as I suggest we should, as environmental problems as hot, we need to recognise there aren't simple solutions to them. And I want to illustrate this with returning to an article that you may have come across, Garrett Hardin's Tragedy of the Commons. Who's heard of the Tragedy of the Commons? Okay. Hardin was a biologist, so he was neither a lawyer or an economist. But in his piece, he talked about the problems created by something being in public ownership. This was the example of open rangeland. If you can just put as many cows on it, farmers will put on as many cows on it, and of course that will deplete the resource. And his argument is often taken as an argument to do one of two things. The first is either you need strict laws to deal with the problem, or secondly, and this is what has been most popular in recent years, is that you privatise things. So owners have an incentive to look after it. But Hardin's argument was not about that. Hardin's argument about a tragedy was, in Whitehead's term, recognising that the tragedy resides in the solemnity of the remorseless working of things, i.e. the tragedy was in social arrangements. And his article was arguing against technical solutions. He defined a technical solution as one that requires a change only in the techniques of the natural sciences, demanding little or nothing in the way of change in human values or ideas of morality. And what I would suggest is that in environmental law there's a tendency not to technical solutions, but to legal solutions or market solutions. So we tend to say, oh yeah, we just need an international treaty, or we just need a piece of legislation, or we just need, the market to look after it. And we don't actually need to think about a change in human values or our ideas of morality. And one can see this again if we go back to the RMA. reference was made yesterday to Simon Upton's statement in the third reading of the bill, where he talked about that the framework was about establishing objectives by a physical bottom line. But he also noted later in a lecture, the Act makes no judgments about the well-being of people or communities. It does not provide guidance on that matter, nor does it invite administrators or judges to pronounce it. This is in thinking about it as the environmental bottom line, there's a vision of the RMA as not being about normative values. And yet environmental protection is about normative values. Now, I can use examples from other jurisdictions. I'm not just saying this is an issue in New Zealand. And it's understandable, because who wants to engage with Gordian knots when you can seemingly engage and just use Velcro? But as any parent of a school-aged child knows, you can only use Velcro for so long on your shoes. And I would also suggest this image and this hope for self-executing solutions has also been present in the application of the Act. And here I realise I'm getting on to provocative ground, but let me go there. About the overall judgment. If we look at the original idea behind this use of the overall judgment approach, this was Justice Grieg in the New Zealand rail case, he suggested this approach because he was recognising that the language of Part 2 had a deliberate openness about the language, its meanings and its connotations. But as Justice Elias has pointed out, and was pointed out in the recent Environmental Defence Society case, there has been a temptation to use the overall judgment approach to actually mask the need to reason through the issues. So, to cite the majority in that case, a danger of the overall judgment approach is that decision makers may conclude too readily that there is a conflict between particular policies, and they may prefer one over another rather than making a thoroughgoing attempt to find a way to reconcile them. So this need to recognise there aren't simple solutions means we have to be ever vigilant. And that leads on to my second consequence of thinking about the RMA as a constitution. And in a sense, it's the kind of flip side of what I've just said, and that is the need to take law seriously. As I've suggested, the image of the RMA and other pieces of legislation is often that they're just instruments. But law is a thick cultural phenomenon. It is ambiguous, it is open to interpretation. And constitutionalism is a recognition that there may be legitimate reasons for disagreement over interpretation. Law is framing our understanding of the world and how we live in it. And as lawyers, particularly with something like the RMA, we need to foster an expertise in what are the different viable interpretations? What are their strengths? What are their weaknesses? What are the legal questions that are raised? And again, pointing to the judgment in the King Salmon case, it suggests to me, as an outsider, it is a prime example of taking law seriously. It's a careful analysis of the text of policies, the processes used, the procedures. It is thinking about the structures of the RMA. Now, saying all that is not to say that there is not room for disagreement, that it does not raise further questions, but it is recognising that that legal detail is very important. And I would also suggest this requires us to look at environmental law through a different lens. In preparing this paper, I was talking to a public lawyer who knew nothing about environmental law, and they said to me in a rather flippant way, they said, yeah, environmental law is so boring, because you just go through the legislation. It's just boring. Now, I thought, well, it's a bit more complicated than that. But what I found really interesting was this person was a constitutional lawyer. And when I was taught constitutional law, what did we do? This was in Australia. You got the Australian Constitution and you went through it in a kind of linear kind of way. But nobody thinks that's boring. Everybody knows that with each article that you come to, you need to understand the different ways it's been interpreted. You need to understand where the case law is going. And I would suggest that we need to think of environmental law in a similar way. And in that regard, we might recognise that the RMA does contain fundamental truths. Sustainable management is something that we want to achieve. But that doesn't end debate, it starts it. And that leads to my final conclusion, my final point and to my conclusion about the consequence of thinking of the RMA as a constitution. And that is the need for ongoing debate. A constitution without debate and disagreement would be a very alarming thing. And something I have always found very striking is everybody knows that freedom of expression is something which creates conflict, is something that we can have discussions about its different meaning, but does not lead us to thinking freedom of expression, oh, it's a dodgy idea. But when it comes to environmental law, there's often an expectation that it's certain. But it seems to me that it's in the same thing. And the precautionary principle, it always fascinated me that people would say it's a terrible principle because it could mean different things. And I would think, yeah, but a rule is meant to be certain. A principle is meant to be open for debate. And so what we can see is that actually that debate is a debate about constitutionalism. And I would suggest inherent in that debate is a tricky tension. A tension on the one hand between recognising that environmental problems are hot, there is a need for dynamic responses, and on the other hand, recognising the need for stability, the need for a stable framework, and that debate is often moving between those two things. Now, again, you may be thinking, well, this is all lovely in a kind of academic way, but it doesn't help us find solutions. But this is where I want to end. What is striking to me as an outsider to New Zealand legal culture is just how rich the discourse over the RMA is. There is a rich body of scholarship. There is a lot of discussion in policy. Even as I came through customs, and I explained to the man why I was here in New Zealand, I got a lecture on the RMA from the man in customs, which at 5:30 in the morning was very impressive. And from the courts. It is a debate which is focused on the overall structure of the RMA. There is a recognition of the framework nature that it plays. We could see that in the Mayor's statement just before. There is a recognition that it is constituting and limiting power. It is also a debate, and this is particularly striking, that is happening at the highest judicial levels. In many other jurisdictions, you do not see the highest courts getting involved in the minutiae of environmental legislation. This is not to say that the work of the Environmental Court is not important, but that it is not operating in isolation. Now, I appreciate that recognising the vibrancy of New Zealand environmental law discourse is not about solutions. But I hope, and this is where hope comes back into it, by offering a different vision, a different way of imagining the RMA, we can begin to see it in a more constructive light. Thank you very much.
Thank you very much, Professor Fisher. Professor Fisher's willing to take questions, and so it'd be really good if we could get some discussion on the very important points she raised in her lecture.
It's a
There's a microphone in the aisle there, on both aisles, if anybody would like to ask a question. Right, perhaps I can. You touched on the issue of the separation of powers, and that this legislation we have actually does develop a model, really, where you have both planning but also policy instruments which become justiciable, in the sense that the courts, and particularly the Specialist Environment Court, can influence policy outcomes. Have you seen that anywhere else in the world?
What I would say, it is a unique feature of New Zealand legal culture. You can see versions of it, for example, in the UK, that under the 2004 legislation, sorry, this sounds so boring and technical. I'm a planning kind of nerd. Under that piece of legislation, you can see that courts can judicially review development schemes. But that's very different from the role that you see the Environmental Court playing. But again, I would suggest this reflects the hot nature of the situations they're dealing with. We need to recognise that these plans are creating frames. It's important that that frame making is accountable.
That's very, very helpful. Martin?
Thank you, Professor Fisher, for setting the scene for this morning and this afternoon's discussion about our environmental law system in New Zealand. Very insightful perspectives there, and I was trying to encapsulate in my mind what I think you have delivered, which is the idea that we should not look to the RMA in an immediate sense for the solutions, but see it as the framework through which those solutions to these hot issues might be realised. And I took to heart your idea of channeling conflict to a constructive outcome. From the experience overseas, maybe in Europe, from your research, if we are to look through that framework to find specific answers to specific problems, do you have a sense as to whether judicial processes and/or collaborative processes by the communities affected are more likely to achieve those specific solutions?
Okay, thank you. It's a great question. In relation to the specific question, and sorry, this is going to be me very, very academic. Judicial can mean many different things. I mean, I think this is where my point about environmental law creating new separation of powers frameworks. If we look at different environmental courts across the world, in actual fact, they have many different types of powers. So in thinking about a judicial solution, we need to recognise these are judicial in the sense that they have the triadic structure that courts do. You have a party here, you have parties here, this party makes the decision. But the different forms they can take from that can be varied. And I stress that because what I would suggest is that the distinction between collaborative solutions in communities and judicial sort of solutions is not a sharp one. That what we see is that they're coming together. Often, for example, courts are acting as the forums for the collaborative solutions. The second thing I would also say about that conflict, and in preparing this morning, I was reminded of a comment that Louis Jaffe, the great American administrative lawyer, made. And he made the point that administration is the complete mirror of our people. And it is about awakening resentment. So in channeling that disagreement, we need to recognise that it will often be channeling resentment as well. Sorry, I don't know if that was a kind of abstract answer.
John Galvin. Professor Fisher, you talked about the need to look at environmental law through a different lens. And when I hear that phrase, tragedy of the commons, I sometimes wonder what iwi in New Zealand would think about that. As I understand the way they managed things, it was often managed in common, and they might sort of object to that sort of concept of a tragedy of the commons. how far do Indigenous values and Indigenous laws, how far might they lead us to look at RMA law on a different lens, through a different lens?
Okay, thank you. Another great question. And I must admit, I don't know a lot about Indigenous law. But I think, and again, I'm thinking about the work of the late and great Eleanor Ostrom, is that what we see is even, again, thinking, what is a commons? How do we even begin to think about our physical space? And there are many different ways that we can imagine what a commons is. And one of the things that you see was the kind of academic response to the work of Harden was to actually explore that, to say that there is no one single vision of a kind of public space. It can be constructed in different ways by different cultures. And so I guess in a sense, what in thinking about environmental law is hot law, the issue about how different parts of society think about the environment, how do they frame the environment, how do they understand it, has to be the starting point. I would also say the same is true of markets. It's very interesting the way people think a market is a market is a market. But markets can be many different things. They're social creations. They can run on many different rules and different principles. Like, if anyone has ever tried to go and buy things in different cultures, have you noticed that the rules of how you buy and sell are very, very different? They're different markets.
Penny Williams. Professor Fisher, there was some discussion yesterday about the number of amendments there's been to the RMA, but if we're thinking about it in terms of it being a constitutional response to a hot situation, then really what we were seeing perhaps yesterday as failures are not failures, are they? They're actually an example of the RMA reframing itself to try and meet the changing situation. Would you agree with that?
Well, I think that's right, but of course what I would then also say is it doesn't mean that every amendment is right. It doesn't mean that the frame, but what we need to recognise is the idea of a stable frame is important, and that frame, in a sense, has to reflect hot situations. If we try and create a frame which is more just an instrument, then we've got a problem.
Philippa Harden-Chapman, thank you very much, Professor Fisher. That was a marvellous talk, and I particularly like your use of discourse and language and emotion. I thought it was great. And reminding us that, in fact, environmental law and public health law were responding to the same situations. And my question to you is, following on the RMA, when there was considered to be a success by across all parties, there was a move to actually get in a similar legislation in public health law, because many of the concerns that environmental health addresses, like land use, housing, transport, also have health effects. And that stalled, and in fact we have myriad bits of legislation often in conflict. And I wonder if you could talk, I'd be really interested to know if other countries have tried to broaden out environmental health to think about very explicitly health consequences and all those other determinants of health.
Thank you. Another great question, which I don't think I can fully answer because I cannot pretend to be an expert in public health. I think my point would be is in different countries, environmental law and the nature of the hot situations varies. So, for example, if I take the UK, environmental law has been a response to the health problems created by industrialisation in the 18th and 19th century. That the type of problems that it's had to deal with have also been because in a very small island, people are very much living on top of each other. And that creates both environmental consequences and health consequences. So that doesn't answer your question, but I agree, it's an important part of the equation.
Eugenie Sage, Green MP. Thank you, Professor Fisher, for a very stimulating lecture. My question is around your discussion about the separation of powers and the RMA managing the relationship between central and local government, and Mayor Cull's point about the nuances of local decision making. When we've got changes to the RMA which are allowing much greater ministerial intervention, the ability to direct councils about what to put in their plans, can you comment on that in the wider world and whether it is actually potentially undermining democracy, which has been a part of the RMA, because it's changing the nature of this relationship between central government and local government, and also the allowing of more politicisation in our environmental law through the appointment of boards of inquiry rather than depending on the Environment Court?
Okay, thank you very much. As I said, and it is striking, and I don't think there's been enough scholarship on it, is that within nearly all environmental law you see this need to manage central and local relations, and that is because hot situations, you can scale them up and you can scale them down. They're about local communities, but they're also about the national community. And I'm not suggesting there is a right answer to how much power central government has and how much power local government has. But what I would stress, and this comes back to my first point about no simple solutions, it often seems to me that debates about those relations are based on the notion that, well, if we do it at this level, that's our solution. So if we have national standards, that provides the solution. Or if we have local democracy, that will have the solution. The reality is we need both. We need that interchange. We need that discussion. And the same is true about the role of politics, which can mean many different things, and the role of courts. We can't pretend that environmental problems belong to one province and not the other. It needs a mixture. Now, I know that suggests a kind of messy answer, but that's the point about problems being hot.
First challenge will be to reach the microphone. Hang on. There we go. Right, I'm Nicola Ween from the University of Otago. Liz, I'm Professor Fisher, sorry. Liz, I'm not sure whether I'm reading too much into what you say about the overall broad judgment approach, which I'll lay my cards on the table and say has never been my favourite approach. But I get the idea that you're saying that by using that kind of approach, we're almost kind of fudging the issue and not really engaging with the questions that we need to engage in, given that the RMA is has this constitutional element or nature to it. Okay, so one of the things that has been suggested in the amendments to the RMA is that the overall broad judgment approach is in fact put into the Act. And so I wonder whether you have any thoughts about the implications of us actually putting that test into the legislation and expressing it in there, whether the effect that may have or could potentially have for us not engaging in the kind of debate that the RMA really needs us to participate in.
Okay, thank you. Another great question. I guess I'm the world's worst at predicting what happens to the law. I remember saying that the Human Rights Act, we would not get many cases in the UK, so don't trust any prediction that I make. I mean, I agree. You've got my argument. You've depicted it correctly. And what I would say is it's very tempting with hard questions to do that. The other example I would use is the use of deference with the Human Rights Act in the UK. It's very tempting just to say, oh, we'll defer to the primary decision maker and we don't have to think about the reasoning. In relation to what would happen if the overall judgment approach was put into the legislation, well, different things could happen. Because as I've suggested in my lecture and I suggest in the paper, there are different ways that you could interpret overall judgment. You could recognise that overall judgment is about the fact that the language of the legislation is open to interpretation, that you need a discussion about what judgment means. You could see a series of judgments which was focusing on the reasoning of the judgment of the decision maker. Or you could see overall judgment as just a label, as a solution. So I think there's potential there to see it in different ways.
Well, on your behalf, I would like to thank you, Professor Fisher. Your talk has actually highlighted something that confronts us as practitioners every day within the framework of the RMA, and that is what informs the discretion of the decision maker. And the Part 2 provisions of the RMA, the principles, of course, are in administrative law terms mandatory considerations that inform the decision maker. But part of our challenge has been reading those principles as if they were standards or rules, in the sense of saying, unless there's something in Part 2, unless there's something highlighted, then we shouldn't be addressing it. And the reality is that principles that inform a discretion in environmental law, such as the precautionary principle, we've had a problem where people have said, well, it's not mentioned specifically in the Act. So this has been a wonderful talk and keeps us activated and thinking about the way we operate within that framework. So, ladies and gentlemen, would you thank Professor Fisher in the usual way?
Ladies and gentlemen, we are going to go into our second keynote. I'm just going to do a little bit of housekeeping. So this isn't officially a break, but if anyone like me has had too many coffees, feel free to race out there. This has so far been fascinating, and just in the very short time I've been here, I've realised that my thoughts that we wouldn't be hearing about politics after last weekend are completely wrong, which is good. We have a large German friend making a guest appearance later on today. No, unlike the moment of truth, you will learn something new today. Ladies and gentlemen, I want to take this chance to thank all of the sponsors, without whom events like this just simply can't happen. So I'm going to go through these. Keynote session sponsor, Rossel McVeigh. Name-badge sponsor, Boffa Miskell. Anderson Lloyd Lawyers. TDG. New Zealand Transport Agency. Bentley & Co. Kensington Swan. Golder Associates. The Clutha District Council. Cubit Consulting Limited. Galloway Cook Allen Lawyers, Chapman Tripp, and Fairway. If we could have a round of applause for all of the sponsors. I'm also seeing as people are taking the opportunity, I'd like to explain a little bit about when you're in the town hall later on for the morning tea and the lunch and then the afternoon tea breaks, you'll see 8 screens around the room. These are the poster presentations. They'll be showing all day today and tomorrow. The screens will rotate. Each one has 2 presentations. They'll screen for about 5 minutes each and switch around. However, at lunchtime today, the presenters of these poster presentations will be there for half an hour for each one. So if you have questions, if you want any more explanation, if you want to talk to the people who put these presentations together, that's your opportunity to do that. And I'll just go through who's going to be doing what when. Between 12:30 and 1 o'clock, the following presenters and their presentations will be, they'll be just standing beside the posters so you can meet them. Lynn Bauer with Crisis What Crisis, Stephen Childs, Raising the Bar in the Management of State Highway Noise, Kevin Council, Measuring Economic Wellbeing in the RMA, Matt Pine, Marine Larvae, Helen Rouse and Rob Britton, Pathways to Change, Michael Stephen, a theoretical model for the aesthetic evaluation of landscape. Thanks for the catchy title, Michael. Helen Rouse and Ned Norton, Limits Through the Looking Glass. Oh, sorry. So the following 6, up until Michael Stephen, they'll be presenting between 12:30 and 1. Then at 1 o'clock, they'll switch over for half an hour. And from 1 o'clock, Helen Rouse and Ned Norton, Limits Through the Looking Glass. Michael Stephen, Applying an Environmental Experience Model to the Aesthetic Evaluation of Landscape. Greg Severinson, Letting Our Standards Slip. Richard Turai, Christchurch Southern Motorway 2. Christine Scott and Susan Wiley, the Ruitanova water storage. There are also student posters on mining and conservation areas, public participation, a comparison of regimes, precaution in New Zealand's environmental law, and marine protected areas. If we can have a round of applause again for all the presentations, just to get the blood flowing. I must point out, it doesn't matter what gig I do, whether it's a comedy club or a conference, nobody sits in the front. I'm not going to go after you today. Feel free if you want to move forward. There's plenty of seats. Okay. Sorry. You had something? Roy, would you like to? Sorry, excuse me 1 second. Okay, slight change in just who's doing what now. We are going to go into our next keynote presentation, and again, I'd like to invite Dr. Royden Somerville, QC, to chair our next presentation. Dr. Somerville.
Kia ora tātou. It's my privilege now to introduce our next keynote speaker, Professor J.B. Ruhl. When the conference committee confirmed that Professor Ruhl had accepted an invitation to speak, I knew it meant that the conference would have the benefit of hearing the views of an eminent scholar and prodigious writer whose influence internationally has been significant in areas of law and policy and debates around ecosystem management, resilience theory, ecosystem services, and adaptive management. For example, earlier this year, Professor Ruhl and Robin Cundis-Craig wrote an article on designing adaptive law for adaptive management and actually attached to that article a Model Adaptive Management Procedure Act, which is very informative and well worth looking at. Professor Ruhl holds the David Daniels Allen Distinguished Chair of Law at Vanderbilt Law School and is co-director of the Energy, Environment and Land Use Program. And as I've mentioned, that if you do read the academic articles that appear in all the leading law reviews in the United States of Professor Ruhl, you'll appreciate the depth of his research and the very, very high standard of scholarship. It gives me great pleasure to invite Professor Ruhl to speak to us.
Thank you so much, Royden, for that warm introduction. It's such a great pleasure to be here. I've actually been to Dunedin before, so this is my second chance to be in your lovely city. I need to thank also a few other people, Nicola Ween and Rachel Brooking, who extended the invitation via Skype and introduced me to some of the concepts that would be covered in this wonderful conference. Also Rachel Cook for getting me here safely, who organized my travel. And I'm thankful not only for the chance to be here and learn about your natural resources challenges and legal framework, but also for the bragging rights that this has given me. I have a number of colleagues who travel widely and frequently, and the other day we were out to lunch and the subject of who's traveling where came up, and one colleague going to Paris, the next colleague said, oh, I'm going to Montreal, next one down to Chile, and then they came to me and I said, oh, well, I went to Washington, D.C. last week. That was not impressive. I said, oh, that's right, I'm going to New Zealand next week. That was the showstopper, I have to say. No one could top that. And everyone in the United States wants to come to New Zealand, I guarantee you. Also, quite ironically though, on my way out of the building, I had my little wheelie bag. A number of my law students said, oh, Professor Ruhl, it's too bad you're leaving. Lord is coming to Nashville tonight. Now, I had not heard of that Lord, your Lord, that is, so I thought, my heavens, I'm missing something really big. My students explained to me who Lord was, or is, and it was clear to me that they thought the exchange was actually pretty good in their favor. They were getting Lord, and you're getting me in exchange. And they didn't seem to miss me that much. This has been a wonderful learning experience. I have had little prior knowledge of the RMA and the related issues. This has been a bit of a crash course. I started doing some reading in preparation before coming over here, and in the short time I've been here, that has my knowledge has really expanded. Yesterday's sessions were wonderful. Much like Liz, I got a lecture on my arrival, not at customs, but rather the lovely driver, Roy, a 75-year-old man who whisked me from the airport to the hotel, and as soon as he knew I was here, I had a 15-minute lecture on the RMA. So I knew I'd come to the right place. I am not a comparative lawyer by nature. It's enough for me just to keep track of what's going on in the U.S., but it's wonderful to get out of that bubble now and then and learn about other systems and take that back to the U.S. On the other hand, I flew 10,000 miles through 17 time zones, and I find actually many parallels among the differences. Many terms used yesterday by Royden and Judge Kenderdine are deeply in play in the United States. And so perhaps there's something to be learned by examining the U.S. experience, something that you might learn, and I certainly hope to learn in return. I also want to thank Liz Fisher for that thoughtful opening to this day. My talk traces a long process of gradual transformation of U.S. conservation law over the last 25 years, and much of what Liz had to say frames that process. And I think it's very important to always keep track of that bigger picture as you get sort of in the trenches of change. So I'm going to examine a number of concepts that have slowly but surely infiltrated U.S. conservation law and seem to be also on your minds here in New Zealand. Okay, good. So just to go through what I'll try to cover today, a brief introduction to the structure of U.S. conservation law, and then an orientation to how these key concepts I'd like to cover have come into play in the U.S. There are challenges to converting them into hard law to apply, and I'll go through just a description of how far each of these concepts has gained traction or infiltrated the law. And I'd like to step back and assess the effects of the trend, a prediction of where the trend might be headed, and offer some conclusions, perhaps even speculate about what these might offer for New Zealand. Now, U.S. conservation law has a number of attributes that I would say are different from New Zealand. Most particularly, we have no anchor conservation law. There is no comprehensive national conservation regime. We've fragmented conservation into a variety of different laws that fit into different categories. So we have regulatory laws like the Endangered Species Act and our Clean Water Act Section 404, which governs wetlands conservation. And these apply to both public and private lands. So they have engendered much controversy, especially in the private land context. We have a number of public lands laws, the National Forest Management Act, the Wilderness Act, and the list goes on. We have about 26 different public land management units at the federal level alone. So we have, and they cover a wide variety of types of management objectives, everything from managing for wilderness to managing for multiple uses and sustained yield in the national forests. The multiple use acts are sort of plagued by this balance between extraction, recreation, and preservation. I'm not sure what that precreation means. That's a typo, of course. We haven't gotten that far yet. And I find in those statutes in particular, this struggle between development, extraction, and preservation seems to have some corollaries to your RMA debate. We have a number of intergovernmental planning laws. So the Coastal Zone Management Act is a federal law that encourages states to engage in coastal planning and offers incentives to states to do so if they follow national policy standards. We have a number of incentive-based conservation laws. Those are particularly concentrated in the Farm Bill that offers incentives to agriculture to engage in conservation practices on what might otherwise be active farmland. We have a number of assessment laws. Our perhaps most iconic environmental law, the National Environmental Policy Act, requires assessment of the environmental impacts of federal agency actions, including funding and permitting actions, so it can apply to actions that are actually carried out by private or state and local actors. NEPA is much revered by many in the United States, but it is ultimately simply a procedural law. The assessment process does not require any particular choice of alternatives, simply an explanation of alternatives and an exploration or examination of their impacts, but it is ultimately simply a procedure. And of course, we have many funding laws that fund conservation. And just one example is Section 6 of the Endangered Species Act provides funding to private and state entities that engage in conservation of endangered species, threatened species, or species that might become that way. Now, at the state level, states vary widely in terms of how much they duplicate the federal system in terms of breadth and approaches, or not. So some states would be held out as quite active in terms of conservation across all of those approaches. California would be one, Oregon another, and some states are quite inactive in that sense. And then at the local level, mostly I would say local conservation in the U.S. is focused on parks and recreation, and to the extent there's a conservation objective beyond that, it's usually carried out through local zoning that is not implementing any national standard, but rather is a power that local governments have via state enabling laws, and they may be pursuing state conservation goals, but they're generally left to themselves to define that, although those zoning powers are limited in terms of how far they can go. So a brief introduction to U.S. conservation law. The upshot of that structure, and this may be where there are some differences, is that at the utmost level, federal legislative inertia has left innovation work to the agencies. We have had no major federal conservation legislation or environmental legislation of any kind in the U.S. Since 1990. A couple of tweaks here and there, but nothing that would be game-changing in any sense. However, many of our laws are so broadly written that federal agencies have wide latitude to integrate new ideas up to a point within and be consistent with the statutory structure. And the courts more or less police that process. At some point, agencies may go too far in innovating, and the courts will draw the box. This does make it easier, or easy, that's a relative term, but agencies can experiment, and agencies can pick up new ideas and begin to move them into agency rules, ostensibly to implement now these very old statutes. And I'll give you many examples of that in a minute. It is more difficult to carry this out in our regulatory regimes because private property interests generally are skeptical or wary of this kind of change in regulation. So while it is easy to integrate ideas in particular programs, it's difficult, as fragmented as our system is, to achieve a national scale shift in policy. And certainly our swings in the White House have led to a policy pendulum. There are instances in some of our agencies of rules designed to implement, say, the National Forest Management Act planning process. We've gone through now 5 different rules as the White House changes each time. They just scrap the old rule and come up with a new one. Sound familiar? So in some senses, this process has been tumultuous, but it has at least been moving over time in particular directions that I'll try to map for you in a minute. Now, where is this new conservation language coming from? Since really the 80s, early 90s, the conservation science in particular has reflected a shift in thinking, moving from the stable equilibrium model of ecosystems towards a recognition that ecosystems are much more dynamic. They have disturbance regimes, they have different equilibrium points depending on conditions over time. And so the science of conservation started to undergo tremendous change in the US and I'm sure elsewhere, beginning in the 90s in particular. More recently, many scientists and policymakers have embraced the idea that stationarity is dead. So stationarity referred to the concept that although ecosystems vary over time because they are dynamic, the range of variance was fairly stable. But of course, with climate change in particular, we're finding that the range of variability that we have depended on for infrastructure planning, for ecosystem management, is now changing, and that makes even more difficult to envision a conservation ethic that traditionally in the US has focused on preservation, a sort of static model of, well, let's keep this ecosystem as dynamic as it is, sort of in this state. And there is growing sense in the US that that's simply no longer a viable policy objective, that ecosystems are inherently going to be changing far outside our expected range of variability. So what are we to do? What is conservation? In essence, we're beginning to think that conservation is really on a ride, riding along with the dynamic nature of ecosystems and the emerging no analog future that climate change presents to ecosystems. And so it's a much more dynamic sense of what conservation is rather than a preservationist mode. So my effort here is to ask, how has any of this made its way into hard law and policy to apply? So I'm going to cover 6 concepts, and in essence they've progressed about, not necessarily in this strict chronological order, but more or less have gained traction in our law in this way. So ecosystem management reflects that ecosystems are complex, adaptive systems. They require large-scale management scopes and authorities. Adaptive management is a methodology for making decisions about ecosystems, recognizing that because ecosystems are complex adaptive systems, our method of decision-making should require adaptive, structured, iterative management decisions. And then the science and policy of ecosystem services recognizes, as was discussed yesterday, that ecosystems, besides provisioning values, extraction of timber, water, etc., also provide important regulating services that we tend to take for granted and aren't easily reflected in markets, but that somehow ought to be taken into account in decision making. Now I want to pause here for a moment and just emphasize the importance, of science and its interaction with law. When I was first encountering policy discussions of ecosystem management, for example, both in private practice and later in my academic world, I began to ask some of the agency personnel who were responsible for developing policy, particularly in the Department of Interior, why do you keep using this term ecosystem management? And the response was, it's all our scientists are giving us. It's all about the science. And if our science branch is telling us it's all about ecosystem management, we feel that our policy side of the agency has to reflect that in policy. And so here you see a number of the scientific movements and publications on ecosystem management, and slowly but surely this gravitated over to law, not only ecosystem management, but adaptive management and ecosystem services. And this really took hold between about 1995 and 2005, that the law could no longer really speak about conservation without integrating these essential concepts. Just as an example, the upper right, that blue casebook is I'm a co-author on, and it's the Law of Biodiversity and Ecosystem Management. And there's actually enough of it to fill 1,000 pages. It's not not necessarily coherent, but it's 1,000 pages. We now have JD PhDs in ecosystem management, law, and policy. And I want to come back to this at the end of my talk, but don't lose track of the importance of science and law in a dynamic relationship. Now, the next set of concepts is newer on the scene. Ecological resilience recognizes that ecosystems in their dynamic processes can take on different alternate states or regimes depending on conditions, and resilience of an ecosystem regime reflects the magnitude of disturbance that triggers a shift to an alternative regime. So, for example, we're struggling in the US with the Everglades. Our decades of alteration of the hydrology in the Everglades in Florida and the introduction of agriculture north of the Everglades has shifted the Everglades from the environment it was to one that is now, because of its higher nutrient load that it receives from agriculture, is more cattail and marshy looking than what the Everglades originally were. And we're trying to now get it back. And we're finding it's much harder to return to the prior equilibrium than it was to shift it in the first place. It will cost literally billions. We have earmarked $14 billion to replumb the Everglades to try and get it back to its original state. Also, social ecological systems is a concept that is we're finding percolating up in much of the social science and now ecological science literature, recognizes that, and this point was again made yesterday, that economy is nested in society, society is nested in the environment, and so we have to understand that society and the environment are co-evolving adaptive systems. We can't manage one without the other if we expect to have a sensible environmental policy. And one metric of a social ecological system is its resilience, its overall resilience to disturbance. And lastly, the concept of adaptive governance is very much in play in the US. That basically we need a more adaptive system of governance in order to really make best use of the concepts of ecosystem management, ecosystem services, etc. And again, you're finding the glimmer of this law-science dynamic. So on the science side, both social and physical, we're seeing the word resilience, social ecological systems popping up all over, and we're starting now to see the lawyers pick up the idea and begin to think about how do we translate that science into law. The book on the top right, Social Ecological Resilience in Law, is a very interesting undertaking. I had the pleasure of taking part in it. It teamed lawyer with scientist, and we were responsible for writing a chapter that would translate the law for scientists and the science for lawyers on particular applications of resilience and social ecological theory. So the holistic idea, I would say, is we're trying to develop an adaptive governance institution to adaptively manage at ecosystem scales the resilience, natural capital, and ecosystem services profiles of social ecological systems. Now that's a mouthful. And clearly you can't just, well, you could try, but you can't just write a law and say, go do that, right? So how do you take that and translate it into law? And anytime I sit down with a bunch of scientists, which I do frequently, and listen to their thinking about resilience and thinking about social ecological systems, I love to soak it up. And they know I'm going to say this sooner or later, the ones who are used to me. I'll say, that's great. Write it up. Write it into law. And they freeze. And that's the project, right? That's the real project that has to take place between lawyers and scientists, is how do we embody these principles in law that courts and other institutions can actually use. So in terms of turning this into law to apply, there is certainly the promise that the bottom-up science percolates into agency policy, and that gets turned into law over time, and that's a process that has certainly happened. The phase one principles, the phase one principles, I mean ecosystem management, adaptive management, and ecosystem services, have made significant gains, and I'll document some of those for you. And the phase two, resilience, social ecological systems, and adaptive governance, are showing much proliferation in the science, and so one could expect this gradual process of transporting over to law. And ultimately, I think we just don't have a choice. That this construct, these 6 concepts, are much better frame for thinking about how we deal with climate change, and old models simply don't work. Now, there are a number of problems that we face in the United States. As I said, there's been no federal legislative reform since 1990, so very few of these concepts actually appear in federal legislation. It's agencies working hard to find hooks to hang these hats on and transform policy themselves. We have a complex federalism system, federal, state, local, and this is a multi-scalar process, and it's very difficult to know who's exactly doing what, especially when at each level, horizontally, the law is quite fragmented into many different statutes. We have the constant problem in the United States of conservation policy having to deal with fragmented public and private lands. And so if the National Forest Service is trying to manage a national forest using these principles, its ability to do so ends at the boundary of the national forest. It's very difficult it's not even difficult, they can't project that into the private land world. The Endangered Species Act has really become the principal conservation regulation statute for private land. And it's quite limited in the sense that it is only about endangered species. Our conventional administrative law system is quite front-end in its decision-making process. By that I mean we require agencies to engage in extensive analysis of the impacts of their decisions through environmental impact statements, extensive public participation, judicial review, and so we tend to front-end a lot of the thinking, and that is a disincentive to agencies to trying to implement adaptive processes over time, because anytime they change their mind, they change their decision, which of course is the point of adaptive management, they are opening the doors to another round of litigation. We also have the obvious funding constraints and simply the difficulty of translating these open-ended concepts into law. And I don't want to suggest there isn't pushback in the United States. In fact, it's coming from all directions and even from the center. On the conservative side of things, there is a concern that these new ideas will lead to the disruption of private property rights, that they will unduly inflate environmental values over economic values, and that agencies will have too much discretion. We're handing just too much over to the agencies in terms of decision-making discretion. And the weapon of choice for that critique has been cost-benefit analysis in the White House and the stalling of regulations in a process that requires agencies to go through an arduous justification of the costs and benefits of their rules. And yet on the other side, we find the same concerns, although in different clothing. The left critique, the liberal critique, is that these ideas will disrupt property rights, but different property rights. There's tremendous concern that the effect of some of these ideas, especially ecosystem services, will tend to displace indigenous populations' sense of property. There is a concern that this will commoditize nature if we reduce everything to a valuation metric, that it diminishes the intrinsic and ecocentric purposes of conservation. Again, agencies will have too much discretion. There's a deep suspicion in the United States of, I think, discretion in general. And when too much gets concentrated in one institution, we tend to become wary. How do we control that discretion? How do we check it? How do we make that institution accountable? And this clearly is an agenda that relies heavily on agencies. And I would say the weapon of choice for this critique has been the Endangered Species Act and NEPA. Slow down, change, challenge all decisions, the Endangered Species Act is quite powerful in that sense. It allows, in essence, to cut through other statutory regimes as in essence, a biological bottom line. It's our closest, I think, analog to that concept here. But it can be used in a way that stalls or limits innovation. And then from the center, there's concern that this is just all very new and different. Don't rock the boat. We've got things all figured out. And now you're bringing in concepts like resilience and social ecological systems, and now we're going to have to figure it all out again. Don't upset the balance of power. And of course, the weapon of choice there is just inertia. So I emphasize that just to point out that this has not been a problem-free process. Also now, a quick aside, why haven't I mentioned sustainability and the precautionary principle? Well, of course, one critique is those are hard to define in law to apply, but I would say we'll try defining resilience. Same problem. I think more to the point is sustainability in our conservation context in the U.S. has a bit of baggage. So, as I mentioned, many of our public land laws have adopted what is known as a multiple-use sustained yield mandate, and that has been associated with sustained extraction. So sustainability in the conservation context in the U.S. Doesn't always mean the same thing to everyone. And both of these terms have become somewhat toxic in the political arena. Sustainability is associated by many conservatives with internationalism. That's a bad word in the U.S. I'm embarrassed to say this. The county in which I live passed a resolution declaring that sustainability was bad, and its attempt by the international movement, whatever that is, to impose Agenda 21. And I actually should have asked some of our commissioners, do you even know what Agenda 21 is? I mean, they just heard about it. And on the other hand, environmentalists often associate sustainability with sustainable development, emphasizing that second word. It's seen as a way to perpetuate development. So sustainability in the U.S., it's a touchy subject, and I think conservation, this conservation new language has done well to avoid incorporating the term. The precautionary principle in general in the U.S. runs counter to our general use of cost-benefit analysis. We have, overall, although there are exceptions, our environmental law regime is what I would call a type 1 error avoidance regime. We put the burden on the proponent of environmental policy to prove that it's not a false hypothesis. So we're quite conservative in terms of letting new ideas in. And there are certainly instances in which American environmental law implements what could be called a precautionary policy. We may say, well, find the public health limit of this pollutant in the ambient concentrations and then add a margin of error. But it's never used under that term. It's sort of operationalized in a very specific way. Now, to some extent, some of these ideas provide a workaround. Many of the objectives of sustainability and precaution can be integrated into resilience thinking without having to actually use the terms. So, how have these concepts fared in law and policy in the U.S.? I would say that ecosystem management is firmly entrenched, particularly in the public lands context. An article in 1994, What is Ecosystem Management, by Grumbine in the journal Conservation Biology, really fueled the movement by synthesizing the scientific literature and then translating it into a policy agenda. The concept was embraced by Vice President Al Gore in his regulatory reinvention project under President Clinton in the 1990s. He ordered federal agencies who had authority in the conservation realm to outline how they would use the concept of ecosystem management. And our Government Accountability Office and the Congressional Research Service, bipartisan or nonpartisan advisory agencies, assessed the progress agencies had made in 1994 and deemed them promising. It showed up relatively early in federal legislation, and it was then easily adopted by our public land management agencies, even without no legislative reform, given the open-ended nature of their statutes. Today, and I did go to Washington, D.C. 2 weeks ago and spent considerable time with a number of federal agency officials, and ecosystem management is just firmly entrenched in the public lands agencies. It's been harder to find ways to apply it in specific pollution control laws and private land regulation. But even there, that's really what agencies are thinking about. So I would say we have, although we have no ecosystem management law, we have basically an ecosystem management regime at the federal level and state level as well. Adaptive management. So adaptive management in the U.S. traces its roots to Buzz Holling's 1977 book, Adaptive Environmental Assessment and Management. He actually was in Canada at the time, and then he moved to the University of Florida. And that was a very influential book that was easily picked up when ecosystem management was gaining steam in the 90s and was perceived by federal agencies as a necessary method for implementing ecosystem management. So adaptive management relies on, again, this idea that we set goals and models for whatever we're trying to manage, a forest, and we implement our decision process rather than all up front, let's decide today how we want this forest to be managed for the next 20 years. Rather, we accept that we will be changing our minds along the way. So we adapt to new information, to changing conditions through an iterative decision-making process. This first was embraced in federal policy in 1995 when the agency responsible for the Endangered Species Act announced that it would use adaptive management in its permitting process. So when it allows development to take place in a way that might harm an endangered species, it will require mitigation, compensatory mitigation, but also build into the permit an adaptive management mechanism that will require that project to constantly reevaluate and perhaps even change its management system. And it's now been adopted in dozens of statutes, executive orders. Corps of Engineers has adopted it for the Everglades. Corps of Engineers and EPA, which administer the Wetlands Protection Law, have adopted it as their compensatory mitigation regime. President Obama adopted adaptive management in an executive order directing the federal agencies that have responsibility in the Chesapeake Bay to use adaptive management. And the Forest Service recently issued a regulation for how it will manage national forests and essentially adopted adaptive management as its decision-making method. Now the problem is that it's easy to say we're going to decide things iteratively, we're going to adapt, and the problem is it's oftentimes abstractly defined, it's underfunded, it relies on monitoring, so we have to have the funding for monitoring, and it's really only been partially implemented. In fact, in President Obama's Chesapeake Bay order, never defines what adaptive management is, just sort of says agencies, go do that. And agencies have found that harder to do in reality. And so co-author of mine, Rob Fishman, and I have traced the evolution of adaptive management in federal policy and discussed how it seems to have stalled at a kind of light version, if you will. And I'll be talking more about that this afternoon. Ecosystem services has also really been mainstreamed in the U.S. It picked up tremendous steam with the publication by Gretchen Daly of Nature's Services, a fabulous book that sort of describes the different services we receive from different types of ecosystems, forests, coastal, etc. Bob Costanza made a splash in '97 as well in Nature magazine, where he estimated the global ecosystem service value at something like $30 trillion. It's a number that you don't really know what to do with, but his point was there's a lot of value out there we're not being reflected in markets. EPA, beginning in the late 90s, formed a research unit called the Ecosystem Services Research Project, in which it was designed to conduct scientific research on ecosystem services to inform the policy side of the agency. And of course, the Millennium Ecosystem Assessment helped sort of crystallize for policy purposes what ecosystem services are. Beginning in 2008, we started to see this picked up in law. Amazingly, Congress passed the Farm Bill in 2008. That's a 5-year process. Every 5 years, we sort of rethink what we want to do with farms. And it starts out as a, well, let's rethink, and it just goes back to what it was. But in 2008, they did add a provision requiring the Department of Agriculture to implement an ecosystem services market office to try and help farmers take advantage of possible markets for ecosystem services. In 2008, the EPA and Corps of Engineers for the Wetlands Law used ecosystem services as part of the compensatory mitigation analysis. So at a site that was experiencing the loss of wetlands, and the rule requires mitigation by enhancement of areas elsewhere, they also want to be sure that the ecosystem services are mitigated as well. And the Forest Service in 2012 adopted ecosystem services as one of the metrics and purposes of its planning process. 2011, the President's Council on Science issued a major report suggesting that the federal government go even further. And at the meeting in DC 2 weeks ago, I was told by a number of agency officials that the White House is about to announce in a few months a major initiative that will sort of like Al Gore's regulatory invention, do the same thing, require agencies across the board to examine how they could integrate ecosystem services into their policies. It has been hard for that concept to gain traction in the private market world. In other words, people aren't trading ecosystem services in sort of an open market context. There have been a few examples of that where, in particularly around water, where local governments have sought to have paid ranchers. In Florida, there's one project like this, to change their ranching practices to increase groundwater recharge in order to increase municipal water supply. So ecological resilience, so this is the phase 2, the newer concepts, right? And it has yet to appear in federal law as a concept, as written into law, resilience. It has appeared in some agency policies. So for example, the Endangered Species Act policies recognize the importance of species diversity to the resilience of ecosystems. But those policies are not hard law to apply. It's just sort of it's informing us how the agency's thinking about its mission. What I will say is that in the past year, we have seen the term climate resilience pop up repeatedly in federal policy. So on September 22nd, President Obama issued an executive order ordering agencies involved in international projects to enhance climate resilience in other nations. And so I think it was yesterday, although after 17 time zones, I don't really know what yesterday means anymore. Is this tomorrow? But just, well, on September 24th in the US, the EPA administrator used the term climate resilience in an updated statement on the Great Lakes Restoration Initiative. That term climate resilience is gaining not only sort of a scientific and policy resonance, but that's popping up so much in policy statements that I think it will carry along the concept of ecological resilience. I mean, it's really what they're talking about. Now, usually when we see the term climate resilience, it's talking about cities and coastal protection, but I think it will carry along the idea of ecological resilience. And I heard again that in connection with this big push by the White House to require agencies to think about ecosystem services, that in addition, it will project or require agencies to think about those in terms of enhancing ecological resilience. So more to come soon on that topic, I think. Social ecological systems, that concept is nowhere to be found in federal law. I think it's still just too new. Now, of course, I say Nobel Prize, yes. I mean, that is Elinor Ostrom's larger project, is the social ecological system thinking. But I think it will be some time before we see that picked up as a legal concept in the US. And then adaptive governance, kind of the holy grail, that's what we all want. We'd love adaptive governance, wouldn't we, so long as it adapts the way we want it to. And I think that we haven't seen that term yet. I don't think it's really a term that I would expect to be specified in law. It's more of an emergent product of thinking adaptively. So conclusions, where are we now in the US? Clearly, ecosystem management is a dominant theme. It has swept public land management agencies. It is embodied in policies. It's embodied in legislation. I think that is a good thing. I think it has brought order to a somewhat chaotic multiple-use regime model. I think it has instilled a greater link between science and policy. Adaptive management has been along for the ride, but I think it's just facing some realities that it's difficult to practice adaptive management in a funding-starved environment, and it's also difficult to practice it given our front-end focus of our administrative system. And again, I'll go into more detail on that this afternoon in the adaptive management workshop. Ecosystem services and ecological resilience, I think within the next year we will see major movement in federal policy on that, and I think states tend to follow. There is pushback, but I think in particular with the growing attention to climate change, these will become mainstreamed. And then the other two, social ecological systems, adaptive governance theories, I mean, I think those will be important background policy concepts. Those will be part of the dialogue. Whether they actually are, experience uptake in actual legal text, I wouldn't expect it anytime soon, but I wouldn't be too surprised if it happened. Where's this headed? I think that the train has left the station. I think even with changes in the White House or Congress, the concepts of ecosystem management, adaptive management, ecosystem services are just so ingrained now that shifts in the politics will simply shift and steer a little left or right. But I don't see federal policy ditching these concepts. And I think ecosystem services will quickly join that status and possibly even resilience as sort of metrics. What are we trying to produce with this conservation system? And I think, as I said, the social ecological systems theory and adaptive governance theory will be background discourse topics. So I don't have a slide for this, but I'd like to conclude with some lessons. First, lessons for environmental law writ large, lessons for anyone. I think that it's clear to me, having been a part of this process for the last 25 years, that environmental law inherently is informed by science. It has to be. And in fact, it's dangerous when environmental law does not integrate accepted science. It just doesn't work. It's environmental law. So environmental science has to be used to design the law. Lessons for New Zealand, I think you're the best judges of that. But I would say, whatever you do with the RMA, don't ignore the science. I think Judge Kenderdean's discussion yesterday was on point, that these scientific concepts don't just exist in the US, and they reflect science as it has developed around the globe. And I think every nation's environmental law would be mistaken if it does not consider how to embody these scientific principles into legal principles. It's a hard process. It's a hot issue. But that makes it all the more important that a group like this open a dialogue about how these concepts will be integrated into New Zealand law, US law, Australian law, UK law. So with that, I'll close, and I'm certainly happy to take questions. Thank you.
Thank you very much, Professor Ruhl. Looks like we're going to be totally overwhelmed by the questions. Marie.
Thanks, Rawdon. My name's Marie Baker-Galloway. So my question's about bottom lines, and you will be picking up that there's debate about whether or not the RMA currently sets bottom lines. We can't even agree on that. Section 5 says that life-supporting capacities to be safeguarded. That's one touchstone. Section 6 says that we have to recognise and provide for protection of significant habitats, so that's another relevant touchstone. Section 7 says we've got to have particular regard to the intrinsic values of ecosystems and protect habitat of trout and salmon. So that's what we've got going into the mix. There's probably others I've forgotten about. What my question is, do you think it would assist or not if the concepts of ecosystem services and or the concepts of resilience were added into that bucket of considerations when talking about bottom lines?
Right. That's a great question. Certainly in the United States, we don't have a bottom lines approach. The closest thing that comes to it, as I understand at least what you mean here in New Zealand by that, would be the Endangered Species Act. And interestingly, the Endangered Species Act is probably the one statute that is least amenable to integrating these concepts. It is a very much a focused, targeted act that allows the agency that implements it, the Fish and Wildlife Service in particular, once it lists a species, all of its actions under that act must be on behalf of that species. In fact, there is a growing sense in the United States that that particular bottom line is in many cases interfering with the broader goal of ecosystem management, because managing for one species increasingly is presenting problems for managing at the ecosystem level, or we have now many instances in which ecosystems include multiple endangered species and it's impossible to manage for one beneficially without harming the other. So I think that inherently ecosystem services, resilience, ecosystem management, adaptive management are not aimed towards defining bottom lines. And so that might be a problem for using them under the RMA to the extent the RMA persists in articulating bottom lines. Yeah, very different there between that and the US. Interesting question.
Rafe?
Yes, thank you, Professor Ruhl. My name is Rafe Chapman. I'm an ecological economist, so not perhaps the normal sort of lawyer or planner that you might find at these conferences. But I really enjoyed your run through these various concepts and how they're evolving. I want to just pick up on a couple of concepts because I'm particularly engaged in the notion of climate change, but I want to pick up on the no analog comment you made and the climate resilience concept that you explored briefly. Can I just say that there is an analog to where we are today on climate, and it was the Pliocene, millions of years ago. We had a concentration of carbon dioxide in the atmosphere of about what we have today. Unfortunately, sea level was about 20 meters higher than what it is today. Now, I say that because the system equilibrates over time. Our oceans are warming, expanding, and so on. Ice caps are melting. So we will get to 20 meters. It's just a matter of time. It's just how long. And the probability is that we will be seeing sea level rise of about 1 to 2 meters per century over the next few hundred years, maybe 1,000, but more likely 500 years or so. So we're heading for that. We are in a state of transition. We are in a state of change, as you point out, and we have to adapt to that. That informs my thinking of how how you look at something like climate resilience. We in fact cannot be resilient to climate at that rate of and magnitude of change, it seems to me. It's a nice try on Obama's part, President Obama. I'm, a great fan of President Obama. I watched his White House speech on climate change the other day. As he pointed out, we're, the first generation to really feel the effects of climate change, and we're the last generation to be able to do anything about it. That sums it up nicely. But the notion of climate resilience therefore has to be challenged, I think. It has to be challenged at a fundamental level. Can we keep on adapting fast enough as the climate changes, as sea level rises, as oceans acidify? And moreover, does it make sense to think in terms of the notion of resilience, which traditionally, of course, has had an engineering connotation that things will bounce back? And then Buzz Hollings and others took it to another level and said, well, actually there's a concept of transformation embedded in resilience, that things transform to another state. And I would argue that that has actually become the new normal, that we are in a constant state of transformation now, decade after decade and century after century, to a state that we don't know will ever be stable again. So in that context, can you comment perhaps on how you see climate resilience?
Sure, there's a lot there to work with. Let me start at the beginning. So the no analog concept, certainly we have analogs on some levels, but the paleoecologists, they tell us, well, we can go back and we know that things really got crazy at different times in the past. And we know that's going to happen again. We just can't tell you what's going to actually happen on the ground. So we don't know exactly what the ecosystem reassembly or disassembly looks like, except that it's going to happen. So what I mean by no analog is we don't really have in conservation policy, ecological conservation policy, a target. We don't know where it's going. So we're managing for change. In terms of climate resilience, so there's a lot of rhetoric behind that in the U.S. I think, by and large, most of what people mean by climate resilience in the U.S. is, by golly, we're not moving this city. We're going to build higher dunes and bigger walls, and and the reality is, Professor Nick Robinson from New York knows this far better than I do. Parts of cities are simply going to go. So resilience, for the most part, is, if you think of the sort of climate adaptation policy rhetoric, it's a resist resilience, or an engineering resilience, not a new equilibrium resilience. After Hurricane Sandy, it was pretty clear. We had the Hurricane Katrina, and it was about, we're going to go back into the Ninth Ward, and you can't change what we had. And Sandy, it's the same thing. I mean, people are just fighting over, they don't like the high dunes because they can't see the water anymore. It's sort of like, well, fine, then you don't have a house, right? I mean, they don't want to move. So in a sense, resilience is, in many ways, aimed at that. Now, there's more to it. There's disaster policy, there's public health policy, et cetera. But climate resilience, I think, hasn't really been designed to carry along ecological resilience as a concept. I just see that what I think is that as the term resilience just starts to permeate policy, it will be easier for the public land management agencies to incorporate it into their ecological management regimes. So they're separate but related. And I certainly think that climate resilience presents tremendous policy problems ahead for the U.S., absolutely. Thank you. Judy?
Yeah, Judy Lawrence, Climate Change Research Institute at Victoria University. I'd just like to bring the comment that Rafe made back to the law and link it to the hope that I heard in Elizabeth Fisher's presentation, where she was basically, I think, saying that the framework law provides a more open framework within which decisions about uncertainty, about the sort of future that we don't know about, can actually be incorporated. And I want to bring it back to a quote that I use often from you, Professor Ruhl, which is that Holling's view of the world gives law the jitters. And you wrote that in a paper a while ago. And I'd like to, if you could elaborate what you meant by that and relate it to Elizabeth Fisher's concept of constitutional law in the way she defined it. Thank you.
Sure, thank you. Yes, I at some point wrote Holling's view of the world gives law the jitters. Adaptive management is, notwithstanding that federal agencies now speak of it as if it's the only way they can go about deciding things, it has received plenty of pushback. It is a different way of making decisions, and the sort of settled practice, we front load, we litigate, and when an agency finally gets through that gauntlet, it would be insane to revisit its decision. But we have been doing it that way for 40 years, and there are a lot of entrenched interests that they know how to play the game, put it mildly. And so adaptive management presents a very different way of agencies carrying out their functions. And no one knows who the winners and losers will be. No one knows how much power actually will be exercised by agencies. And so there's a lot of jitteriness around that concept. Nevertheless, it is certainly being pushed every day further and further by federal agencies. And my afternoon talk will explore how the courts have responded to adaptive management. And slowly but surely we're finding the courts accepting and even to the point of embracing adaptive management as practiced by agencies, but policing it carefully to be sure that accountability and it's not just a promise, but it's actually a plan. Your point about framework law, this is something that this conference is really making me think about because we really don't have one in the US. We've got just dozens and dozens of laws. Now, I said it's easier to find opportunity, somewhat, in some ways, even surreptitiously, agencies just sliding ecosystem management in here and a little resilience there in their policies, and over time it begins to build up into a somewhat cohesive policy. It's also going to be hard to strip that out, right? It's harder to, you can't in one fell swoop make it happen, and you can't in one fell swoop undo it. And that may be one of the downsides of a framework law that I'm picking up, at least in the conversation here, is that in one fell swoop, if the RMA is amended, a lot changes all at once, right? And so it's much harder to pull that off in the US. In some ways, many people are thankful that Congress hasn't amended any laws because we just don't even want to think about what we get. And so I think plenty of people are happy, myself included, with this process of agencies being the innovators, the background of sort of a mosaic of laws that haven't changed much over time, and the courts kind of at the other end making sure that the agencies don't go too far offline from what these laws allow. So it's been a slow process getting it up and running. I think it would be very hard to undo it.
Thank you. Judge? Yes, Professor Ruhl, thank you for a most interesting presentation this morning. Part of my background that drew me to your discussion of a number of these concepts is that it so happens that my late father was a scientist and I was a lawyer. And we engaged in some quite interesting, at times vigorous debates about the wish of the law and lawyers and judges to arrive at some certainty and to rule off on things, and the need for science, not just the wish, but the need for science to continue to advance as science advances, and the tension that therefore exists between those who participate in our, when he was alive then, planning system, now the resource management system, where the scientists, and he became an expert witness in what has now become my court, proceed on the basis that they would like to see future flexibility in decision making, but where parts of the legislation and legal thinking and judicial work require a little bit more certainty to be given. I was particularly interested in your discussion of adaptive management as it appears to be framed in the federal sense in the US, and ecosystem services, let alone resilience, which I perceive to be not as far down the track. And I noted your discussion of them, particularly in the federal area, and in relation to public lands and waters. And I was fascinated to perceive that advance, to gain that sense from you. The sense that I didn't, I think, gain from listening to you, but that might be my fault, not yours, and which I want to ask you about, is whether there's any model that you're aware of in any part of the United States, maybe at a federal level or maybe at a local level somewhere, where perhaps in the way that the Resource Management Act has, to a high degree, I like to think, grappled with the concept of dealing with the multiple issues that society might wish to see addressed. And so, for instance, coming back to the debate that my father and I had, a wish for some certainty perhaps in the economic sense, and in terms of private rights on the one hand, and the need that Judge Kenderdine spoke about yesterday for a recognition of matters that are more in the science area. And I'm just wondering whether there might have been some attempt somewhere in the United States at a lower level than federal perhaps to grapple with resolution of this tension between legal method and scientific method, and produce a consenting mechanism that might be of interest to us as we continue to advance our work.
So, I'm racing through examples and can't think of many. I would think if there are a few isolated examples that I can think of in state laws. And you know, there's a whole, the U.S. Model of states as laboratories of innovation, which is, you know, again, it all depends on which direction they're innovating. Florida, at one time, Florida had a fairly progressive set of laws that did require local and regional. So Florida was unusual in the United States as establishing a number of regional authorities that actually had planning power and had their own legal authority and scientific research branches. These were called the water management districts. And they had authority over wetlands, water use, water quality, and they were really, empowered to use science to implement regulatory outcomes. That has been, to some extent, diminished through successive administrations. The current administration in Florida has not been kind to the growth management regulation, et cetera. I can't think of a state, though, that has truly embraced what you're describing as a sort of real-time science-informed regulatory regime. It's very difficult to pull off, I think, in that sense. Yeah, very difficult.
Well, thank you very much, Professor Ruhl, for your excellent talk, and I think it did disclose that we're probably not too, things aren't as bad as here as I thought. Can I just say that we've had a very stimulating morning with our two guest speakers, Professor Fisher and Professor Ruhl. And if that's a portent of what's coming at this conference, I think it's going to be great. Thank you so much.
It's my pleasure.
Well, thank you, Professor Ruhl. Not only a fantastic speech, but you may have to have somebody explain this to you, but the most eloquent TUI billboard that New Zealand's ever seen. Ladies and gentlemen, can we have a round of applause for all of the speakers you've seen today? And also, Dr. Somerville, thank you very much for sharing with us.